Before sunrise, while most of the country was still asleep, a convoy of unmarked federal vehicles rolled through the gates of one of the most closely guarded private estates in the nation. The timing was precise, deliberate, and impossible to ignore. At exactly 6:47 a.m., court-authorized agents stepped onto the property, carrying sealed seizure orders that would immediately change the course of American political history. This was not a routine enforcement action. This was not a civil dispute or a regulatory matter quietly handled behind closed doors. This was the opening move in what legal experts are already calling the most aggressive asset recovery operation ever directed at a former head of state. Armed federal officers established a perimeter while senior marshals approached the main residence to serve paperwork to private security. Within minutes, the estate was effectively under federal control. Every movement was documented, every room was logged, every valuable item was cross-checked against a pre-approved inventory list authorized by a federal judge after weeks of sealed hearings. The value attached to the seizure authorization was staggering, totaling more than $500 million in assets, allegedly tied to an ongoing criminal investigation that had quietly escalated beyond containment. This wasn't sudden. It had been building for months beneath the surface. Tensions between investigators and the former leader's legal team had steadily worsened as deadlines were missed, subpoenas were challenged, and compliance became selective. According to sources familiar with the case, the breaking point came when prosecutors filed an emergency motion arguing that assets were actively being moved, restructured, or placed beyond the reach of U.S. courts. That motion triggered an expedited judicial review process rarely used outside of organized crime and national security cases. What persuaded the court to act so decisively was not a single document or witness, but a pattern. Financial records obtained from multiple international and domestic institutions reportedly showed a web of transactions that investigators described as deliberate and sophisticated. High-value assets were transferred between shell entities, trusts were activated, ownership structures shifted rapidly. The timing, prosecutors argued, coincided too closely with key developments in the investigation to be coincidental. By the time a magistrate judge reviewed the full evidence package, the concern was no longer theoretical. The court concluded there was a credible risk that assets would disappear entirely if immediate action was not taken. That determination cleared the legal threshold for preservation and seizure orders, allowing federal marshals to move before appeals could stall enforcement. Notification was issued late the previous night. No stay was granted. By dawn, the operation was underway. Inside the residence, agents moved methodically. Nothing was rushed. Nothing was theatrical. Items were photographed, tagged, and cataloged in silence. According to individuals briefed on the process, the inventory spanned more than 100 pages and included rare books, historical artifacts, original artwork, and financial instruments, stored both physically and digitally. Investigators believe many of these assets were acquired during or shortly after periods in which the former leader had access to highly sensitive government information. This is where the case shifts from controversial to explosive. Prosecutors are not alleging simple mismanagement or procedural violations. They are building a theory centered on monetized access. The claim, still unproven in court, is that privileged information was leveraged to secure financial benefits through indirect channels. Foreign-linked payments, favorable business arrangements, and unusually timed transfers form the backbone of the government's argument. Court filings describe financial inflows occurring within narrow windows following classified briefings. While correlation alone is not proof, investigators argue that the volume, timing, and routing of the funds demand explanation. The seized assets, they claim, represent the tangible proceeds of that activity. That assertion is what transformed the case from an investigation into an enforcement action. The legal significance of this moment cannot be overstated. Asset seizures of this scale are typically reserved for cartel leaders, international fraud rings, or national security threats. Applying the same legal tools to a former national leader sends a signal that prosecutors believe their evidence can withstand not just legal scrutiny, but political and historical pressure as well. Judges do not authorize armed seizures lightly. They do so when the alternative is losing jurisdiction entirely. The reaction inside political circles was immediate and volatile. Allies of the former leader described the move as unprecedented overreach, warning that it crossed a line that could never be uncrossed. Others, more cautious, acknowledged that courts do not sign off on such actions without compelling cause. Public statements were carefully worded. Private conversations, according to insiders, were anything but calm. What complicates the situation further is the international dimension now coming into focus. Investigators are reportedly coordinating with foreign financial intelligence units after tracing transactions that crossed multiple jurisdictions within hours. Some of these transfers passed through countries known for strict banking secrecy, requiring diplomatic-level cooperation to access records. That level of coordination is typically reserved for terrorism financing or transnational organized crime. Intelligence professionals watching this unfold are deeply unsettled. The concern is not just legal accountability, but damage assessment. If sensitive information was compromised, even indirectly, the consequences extend far beyond one individual. Entire intelligence streams may need to be reevaluated. Sources could be exposed, methods rendered obsolete, trust with allies strained or broken. Within the former leader's inner circle, the mood is described as panicked. Strategy sessions reportedly stretched through the night as advisors debated how to respond. One faction urged aggressive public confrontation, framing the seizure as proof of systemic corruption. Another warned that escalating rhetoric could backfire legally, especially if statements are interpreted as attempts to intimidate officials or interfere with judicial proceedings. The former leader eventually responded publicly, denouncing the action as illegitimate and politically motivated, insisting the investigation was built on fabrication and malice. Notably absent, however, was any detailed rebuttal of the specific financial allegations outlined in court filings. Legal analysts were quick to notice the gap. Courts care about evidence, not outrage. This moment now sits at the center of a constitutional fault line. It raises questions that go beyond party, personality, or politics. What limits exist on power once someone leaves office? Does status shield assets if those assets are allegedly tied to criminal conduct? And most importantly, can a system built on the principle that no one is above the law enforce that principle when the stakes are this high? As of this morning, the seized assets remain under federal control. Appeals are expected. Additional filings are rumored to be imminent. Investigators continue to present evidence to grand juries, and officials familiar with the case suggest this operation may represent only the first phase. What happens next will not just determine the fate of one individual, but will set precedent for how accountability is enforced at the very highest levels of power. This story is no longer theoretical. The process has begun. The consequences are real, and the next developments may arrive far faster than anyone is prepared for. As the day progressed, the legal shockwaves spread far beyond the seized estate. Within hours, multiple federal courts were placed on alert as emergency filings began moving through the system. The former leader's attorneys challenged the seizures on constitutional grounds, arguing that the action represented an abuse of power and a dangerous expansion of federal authority. But behind closed doors, the tone was very different. According to individuals familiar with the filings, the defense was struggling to construct explanations for transaction records that were already authenticated by banks, auditors, and third-party compliance systems. What makes this case uniquely dangerous is that it does not rely on testimony alone. It is built on timestamps, transfer logs, encrypted communications, and synchronized financial movements across jurisdictions. These are the kinds of records that do not bend under political pressure. They either exist or they do not, and prosecutors appear confident enough in their existence to put their entire credibility on the line. One senior legal analyst described the government's posture as unusually aggressive, not in rhetoric, but in sequencing. Instead of waiting for indictments and then fighting asset recovery afterward, investigators moved preemptively, locking down anything they believe could be dissipated. That choice suggests fear of imminent loss rather than mere strategic advantage. Courts only tolerate that approach when convinced delay would permanently frustrate justice. As more details leaked through legal channels, A clearer picture began to emerge of how investigators believe the alleged scheme functioned. According to summaries reviewed by outside experts, access itself was not sold openly. Instead, influence was monetized indirectly. Sensitive awareness allegedly enhanced bargaining positions, unlocked doors, and shifted negotiations in ways that translated into extraordinary financial benefit. Payments were structured to look like ordinary commercial activity. Consulting fees, licensing arrangements, real estate partnerships, all facially legal, all suspicious in timing and scale. The most damaging element, however, may be communications. Investigators reportedly obtained encrypted messages through lawful warrants that suggest coordination between intermediaries and associates discussing deliverables, timelines, and satisfaction metrics. The language is vague enough to avoid explicit references, but specific enough that analysts believe it correlates with known intelligence briefings. Prosecutors argue this pattern mirrors techniques used in international espionage markets, where sensitive information is never named directly, only implied. This is where national security officials became alarmed. Once intelligence agencies realized the financial investigation was overlapping with classified access timelines, a separate damage assessment was triggered. Analysts began reviewing every instance in which the former leader had direct exposure to sensitive programs. The concern was not just disclosure, but leverage. Information does not have to be handed over physically to be exploited. Sometimes the mere hint of knowledge is enough to shift power. Inside intelligence circles, the mood reportedly turned grim. Former officers described the situation as a nightmare scenario, one they trained for abroad but never expect at home. If classified insights were indirectly used to benefit private interests, the ripple effects could be impossible to fully trace. Allies may question past intelligence sharing. Sources may go silent. Entire networks could collapse under suspicion. The human cost of that possibility weighs heavily on professionals who spent their careers protecting secrets at personal risk. Several former officials spoke anonymously, expressing disbelief that the safeguards built around executive access could be undermined in this way. The assumption has always been that while leaders may make political mistakes, the line between public duty and private enrichment would never be crossed at this scale. Politically, the response fractured along familiar fault lines, but with unusual hesitation. Public defenders of the former leader framed the seizures as authoritarian, warning that no future leader would be safe from retaliation. Yet privately, even sympathetic lawmakers acknowledged the optics were devastating. Photographs of federal officers cataloging luxury assets are hard to reconcile with claims of victimhood, especially when authorized by courts. Moderate figures urged restraint, cautioning that attacking law enforcement could escalate matters. Others pushed for confrontation, insisting that only total resistance would preserve political viability. The contradiction left leadership paralyzed. Supporting the seizures risks alienating a loyal base. Condemning them risks appearing to undermine the rule of law. Meanwhile, investigators continued working quietly. Additional subpoenas were issued. Financial institutions were instructed to freeze specific accounts pending review. Foreign partners provided supplemental documentation, some of it voluntarily. The case, far from slowing, appeared to be accelerating under its own momentum. Legal scholars watching the proceedings began using language rarely heard outside constitutional crises. Words like inflection point and institutional stress test entered the discourse. This was no longer about guilt or innocence alone. It was about whether systems designed to restrain power could function when confronted with the most powerful individual they were ever meant to regulate. One retired appellate judge summarized the dilemma bluntly: if the law retreats here, it retreats everywhere. If it advances recklessly, it risks delegitimizing itself. The balance is unforgiving, and mistakes will echo for generations. As night fell, rumors circulated that additional seizure orders were being prepared, targeting assets held through layered ownership structures not yet publicly identified. Whether those rumors are accurate remains unconfirmed, but the possibility alone has reportedly sent advisors scrambling to map exposure. Once assets are frozen, options narrow rapidly. What is undeniable is that the situation has entered a phase where narrative control is slipping from political hands and settling into legal ones. Courts do not respond to rallies or outrage. They respond to filings, evidence, and precedent. And at this moment, the paper trail appears to favor the side that moved first. This is not the end of the story. It may not even be the beginning of the end. But it is the moment when theory became action, when warnings became enforcement, and when the question of accountability stopped being abstract. The next phase will determine whether this operation stands, expands, or collapses under challenge, and that phase is already underway. By the third day, the country had fully absorbed that this was not a temporary legal skirmish. It was a structural confrontation between personal power and institutional authority, and neither side could retreat without consequences. Court calendars were rearranged, judges cleared time, federal agencies coordinated messaging with unusual discipline, saying little publicly while moving relentlessly behind the scenes. What unsettled many observers was how calm the enforcement side appeared. There were no leaks exaggerating claims, no dramatic press conferences, no victory laps. Officials involved spoke only through filings, and those filings were precise, restrained, and densely supported. That restraint signaled confidence. Prosecutors do not move this way unless they believe reversals are unlikely. Behind that confidence lies the architecture of the case itself. Investigators are not attempting to prove motive through rhetoric or character. They are letting sequence tell the story. Briefing, transfer, asset acquisition, repetition. Over and over again, the same rhythm appears. Defense attorneys can argue coincidence once or twice. Explaining it dozens of times across years and jurisdictions becomes mathematically implausible. As the courts reviewed emergency appeals, one question dominated deliberations: intent. Asset forfeiture law does not require conviction, but it does require probable cause that assets are connected to criminal activity. In this case, judges were asked to decide whether the pattern of conduct rose to that threshold. So far, the answer has been yes. That decision carries enormous implications. It means the judiciary has accepted, at least provisionally, that the alleged conduct is not speculative. It is concrete enough to justify immediate intervention. That alone reshapes the legal battlefield. Once assets are secured, the leverage shifts decisively. Negotiations change. Timelines compress. Risks escalate. Inside political operations aligned with the former leader, the realization set in that public messaging could no longer outrun the evidence. Calls for mass mobilization conflicted with legal advice urging silence. Every statement risked becoming an exhibit. Every accusation invited scrutiny. The strategy narrowed to survival rather than dominance. What truly rattled insiders, however, were quiet confirmations that the investigation was no longer confined to domestic agencies. Foreign financial intelligence units continued supplying data, not under pressure, but under obligation. Mutual legal assistance treaties require cooperation when thresholds are met. Those thresholds, it appears, have been crossed. That international cooperation introduces a permanence that political cycles cannot undo. Administrations change, elections pass, but banking records and treaty obligations persist. Once shared, they cannot be unseen. Once corroborated, they cannot be unsent. The National Security Review, running parallel to the criminal case, has grown equally consequential. Analysts are no longer asking whether information was compromised, but how much and how deeply. Entire access protocols are being reconsidered. The assumption that proximity to power equates to loyalty has been shaken. For intelligence professionals, this is the most painful aspect. The damage is not symbolic. It is operational. When trust erodes, sources disappear. When sources disappear, warnings arrive too late. The cost is measured not in dollars, but in lives and lost foresight. Public reaction continues to polarize, but fatigue is setting in. Outrage burns hot and fast. Documentation endures. As more verified details surface, absolutist narratives struggle to adapt. The story is becoming technical, procedural, and evidence-driven. That favors institutions over personalities. Legal scholars now openly debate whether this moment will redefine post office accountability. For decades, the system relied on norms and restraint. This case tests what happens when norms fail and restraint is replaced by enforcement. The answer will echo long after the individuals involved are gone. If the seizures withstand appeal, they will establish precedent that access cannot be monetized, that influence cannot be laundered, and that the end of a term does not end legal exposure. If they fail, the opposite lesson will be learned just as clearly. As of now, the assets remain frozen, the investigation continues, grand juries remain active, and the silence from enforcement agencies remains unbroken. This is the waiting phase, the most dangerous phase for those under scrutiny. Because while nothing appears to be happening, everything is being prepared. History rarely announces itself cleanly. It unfolds in filings, timestamps, and decisions that seem technical until their consequences are understood. This is one of those moments, a quiet reckoning with loud implications. Whatever the outcome, the line has been crossed. Power has been challenged, the system has responded, and the precedent being written will shape how authority, accountability, and trust coexist in the future. There is no reset from here, only resolution,